Hey guys, we're just about to go, well, we're live right now, and we're just trying to get it on screen here, but I don't see anything on screen, so hopefully, there we go. Perfect. Okay.
Okay, we have people coming in. Hi and good evening.
Hi everybody, thanks for joining us. Myself, Chris Dickinson, I'm here with
Scott Temby.
Scott's an attorney. We're going to be talking about copyright infringement tonight. The whole conversation is going to be probably 15 or 20 minutes, and we'll be taking on your questions, and we'll frame everything up, and hopefully you get a lot out of this. We'll save it after it's over, and I'll post it on my YouTube channel.
And as any good attorney, I have to have some disclaimers. Tonight's for educational purposes only. I'm not providing legal advice to any individuals, but I'm happy to hear questions so we can use those as examples and address those questions and hopefully give you some good information here. But again, consult your own attorney.
That's very accurate.
Got to do my job.
Just so you guys know, Scott and I have known each other for a significant
Long
period
time.
of time. Yeah, we probably shouldn't say how long because then it'll tell you how old we are. Scott's been with us since we even started our business over 11 years ago. But in all of our legal matters, Scott has helped us along the way, and just really thankful to have him along with us.
Thank you.
Let's go ahead and just get it started. Tell us about copyright, Scott. What is it?
Sure. So let me start by telling you what a copyright is not. A copyright is not a patent. It is not a trademark. So the CDP that you see on Chris's photos is not a copyright mark. That's just his trademark or another indicator of his work. But a copyright is a form of protection. It's grounded in the Constitution. It's further detailed into the copyright law that provides for protections in a work of authorship that's reduced to a tangible form. So that's a lot of legal mumbo jumbo for saying something that somebody creates and puts into electronic or a hard version of a document, as well as other forms of writings and pictures. Pictures, the things that you post on Instagram, the content that you write there, those are all copyright protected or can be.
Cool, thank you. So just to dumb it down for people that aren't attorneys like myself, when I put a watermark on my image, it's not affecting the copyright. In other words, I don't need a watermark on my image to copyright my image. Is that correct?
That's correct. So typically what you see for a person who has registered a work with a copyright is what I call the circle C. It's that C with the circle around it, the year, and then the owner of the copyright associated with that. That's the typical type of indicator that something's been registered as a copyright.
Okay.
That mark is optional now.
Okay.
It used to be you had to have that present in order to perfect your copyright, but not anymore.
Okay. So with a circle C on an image, that could be one indicator that a person took another step and actually registered the copyright with the Copyright Office.
That's correct.
Okay.
That's correct. So registering your works is necessary if you want to pursue an infringement of your copyright.
Gotcha.
But it's not required in order to have copyright protection, if that makes sense.
Yep, you bet. So from the minute that an image is created, and we're just, I guess maybe we should just frame this up, that we're talking about images right now. We're not talking about other works of art or derivatives or anything like that.
Right.
Just picture taking. So when I take a picture, that inherent right is already afforded to me, right? From the moment that I take the picture.
From the moment you take the picture and it's captured in a tangible medium.
Okay.
That's the language that's used. That could be the SD card.
Okay.
It could be a hard print. It could be the Polaroid or other format.
Gotcha. Okay.
That's correct.
All right. And once I get that home and I edit my picture and I post it online, it's my property. Not even.
Before that,
it's my property from the moment that I click the shutter. Is that right?
That's correct. So you have your copyright in effect the moment that you complete the work.
Okay.
Publishing it is not required in order to perfect your copyright protections. Publishing a copyright can be protected with publishing or not.
Okay. Okay. So if somebody came into your TAC room, because the majority of my followers are Western based, and I'd venture to guess that almost 99% of them ride a horse. And if somebody went into their TAC room and took some of their TAC out, that would be considered stealing.
Sure.
Pretty simple, right?
That's right.
And it doesn't seem like it's that simple when it comes to images. So a lot of people don't see the value that's placed on an image. They post it out there. Someone, an artist or a photographer posts an image out there, and another person comes along, takes that image, and then reposts that image for, to gain followers or
Sure.
to get someone to come to their page, and in hopes of perhaps buying a T-shirt or something like that. In that kind of situation, would that person be considered infringed upon? Would that photographer then be infringed upon?
Most likely, the answer to that question is yes. Now, there's always exceptions to various legal cases, but typically the general rule is that once a person has completed their copyrighted work and published it, and somebody else takes or duplicates that copyrighted work without permission, that's an infringement.
Gotcha.
And then at that point in time, the owner of the copyright has acts that they can take to address that infringement.
Okay.
Perhaps before we go there, though,
Yeah.
let's talk about what you can do to protect your copyright to begin
Sure.
with. So there's some simple steps that I suggest everybody considers when they're working with their copyrighted materials. The first one would be, in fact, letting people know that it's a copyright work. So it doesn't necessarily have to be imprinted on the image. And one of the beauties of Instagram and other social media networks is that you have the means of adding some content and some language that describes what your work might be. By the way, that writing as well is likely copyrighted, protected. And you can state in there that all rights are reserved, that this is a copyright work, and that you're the owner of that copyright. And that can simply be stated as Circle C, 2019, CD Photog, all rights reserved, just at the very bottom of it.
Okay.
And some other things that can be done is to actually register your works with the Copyright Office and go to www.copyright.gov. It's a great website. It's the government website that allows you to register your copyrights online. And that's the first step in getting your works registered and protected. And that protection will be required if you ever want to pursue an infringement case.
Okay, great. Let's we have between 17 and 20 people that have joined, and if you joined late, I'm Chris, this is Scott. Scott's an attorney. We're talking about copyright infringement and how it affects us on Instagram and how it affects us just in general. Regardless of the classification of photographer that you consider yourself, whether you're an amateur, a hobbyist, a semi-pro, or even a professional who's making a living at this, copyright infringement can affect us all. And the reason that I suppose that I'm so passionate about this is on any given day, I'll get numerous messages from people that follow my account, leading me to other accounts that have reposted my images. Now, in some of those cases, it's just another person reposting that image. But in that case, while they're not going for monetary gain, while they're not trying to sell T-shirts or trying to sell something, it's still technically I haven't given my permission for my work to be distributed.
Correct.
And as a copyright owner, I have exclusive right over that.
You do. And so, again, it's not required to register your work in order to have it copyright protected. That copyright protection comes immediately upon the creation of the work. The registration of it allows you to have some protected rights and gives you some ability to address any infringements that come upon it. But when a person takes your work, they may want to, for example, give credit to it. And that type of credit posting is really just a courtesy. It's a way of acknowledging that this is that other person's work and I'm reposting it here. When they start crossing over into the area of trying to use it for economic gain,
Yes.
that's where there's harm occurring.
That's such a great point. What we're talking about is just a simple act of reposting a picture. Now, it's all innocent. Of course we don't, intend or, mean any
Sometimes
malice.
it's innocent.
Yeah, sometimes it's innocent when we repost an image. But in the event that we repost an image without someone's permission, or we repost an image that isn't even ours, we could be considered in violation of copyright infringement. And someone could, and I have on many occasions, filed copyright infringement reports with Instagram to have that image taken down because my permission wasn't given for that image to be reposted. And when somebody reposts an image of mine and they give me, what we call photo creds, photographer, CD photog, that's nice, but that's only a courtesy.
That's
And
right.
because you're giving attribution, or photo creds, doesn't mean that you have that person's permission to repost that image.
That's right. Again, it's time for a disclaimer. I am not providing individual legal advice to anybody here. This is merely for educational and informational purposes, and any questions that we address are not providing legal advice to any individual, so please consult your own attorney. With that disclaimer.
Wow. That's really good stuff.
Well, thank you. With that disclaimer, I think it's also important to help understand what the copyright process is, because it's really pretty straightforward and simple. The best way to perfect your copyright with the Copyright Office is to do it online. Go to www.copyright.gov. It's a simple online application form, and you can obtain registered copyrights of 150 photographs for a very low fee. $55 is the registration fee for that, and the form is quite simple. There's some specific requirements about how you have to have the individual works labeled and have an index prepared for them. But if I can figure it out, anybody else can figure it out. So it's not that hard. And as a result of that, once you've registered for that Copyright Office, it takes about 6 months on average for a copyright to be perfected. And once you receive that protected copyright, those images that you use in the course of your business, or in the case of many, some hobbyists who result getting some income from that'll allow you the ability to address any infringement. And should you desire to pursue a lawsuit for a significant or willful infringement, you can get some serious statutory damages awarded to you for that.
So are you saying that, or would it be fair to say that if I don't register my images with the Copyright Office, that I don't have, let's say, the keys to the court?
Well, I think that's an interesting way to put it. Your copyright protection comes into existence at the moment that you create the image. But in order to pursue an infringement case and to be successful in achieving the results that you desire, it needs to be registered. So one of the things that registration does is unlock the doors of the courthouse to allow you to pursue that infringement case, as you put it. But it also puts the burden on the infringer to show that they had permission or a right to use of your copyright. And because at that point it's prima facie evidence, so that's a Latin term that means proof of the matter itself, that your work is protected and registered. And so once you have that, then the burden shifts over to the infringer to have to come forward and say, well, I had permission.
Gotcha. Okay. But if you're taking legal action, that's pretty egregious, right?
That's pretty severe. It's usually it's expensive, and even though you may be awarded,
attorneys are expensive.
Some attorneys are expensive. Most attorneys are expensive, and so even though you can be awarded statutory damages as well, and in the case of a willful infringement, up to $150,000. And your attorney's fees, it's still a lengthy process, and it takes some money to get it started.
Gotcha.
But even before that's the end result in trying to address an infringement. There's a lot of work and a lot of steps that are relatively straightforward and simple to do that you can do to address an infringer.
Scott, what remedies do we have if we're not registering our images with the Copyright Office? In a previous photography organization that I was a part of, had multiple thousands of members, and we would always take surveys, and what we found was upwards of 90% of the photographers don't take that additional step and register their images with the Copyright Office.
Sure.
So if we don't register our images with the Copyright Office, what other remedies do we have if someone has infringed upon our copyright?
Sure. Well, the first thing, and perhaps one of the most simple things, is to tell the person that you're aware that they've infringed upon your work, and you're going to politely and directly tell them to stop. You send them a cease and desist letter.
Okay.
And within that, it's pretty straightforward. You set forth the who, what, where, when, and how of your work, the fact that you created it, you own it, when you created it, and that you have evidence that backs that up, whether it be your original files. And you don't have to go into a lot of detail. That just set forth the basic facts that support your ownership of the work.
Okay.
And then the next step would be setting forth what you observed as far as the infringement, and that it was done without your permission. And at that point, that's when you ask them to cease and desist, to immediately remove it or to unpublish it. And if there's any economic gain, you can request that they reimburse you for that economic gain that they realized. And then it doesn't hurt at that point in time to say that a copy of this letter is being provided to your attorney.
Gotcha. I know Getty Images is one of those places that you can buy stock images from. Getty Images is known for a tactic that they use, and that is if somebody takes one of their images without purchasing it, and they track it down, they're going to automatically send an invoice to the person that has done that. Now, they have a massive team behind them to do that. But for somebody,
as well as some pretty sophisticated software.
Sure.
Yeah.
But for somebody like me, that makes a post a day and puts my work out there, if somebody takes my work, would it be okay for me, from a legal standpoint, to just reach out to them via direct message and say, this is my work. I would appreciate it if you take it down. I've not given you any permission. Kind of take those same steps like you were talking.
Sure. So I'm a firm believer in giving people the benefit of the doubt. Clearly, if it's a large organization, a commercial enterprise that's misappropriated or infringed upon your copyright, that's a different scenario. But in most instances, especially in the social media context, I want to give people the benefit and acknowledge that they have infringed unknowingly, not necessarily understanding what the legal requirements are and how they may have stepped over those boundaries. And so providing that type of direct message, that type of communication, letting them know that you're aware of it, and respectfully but directly instructing and asking them to depublish is a very good first step. Be reasonable.
Now, I've done that many times to no avail. And speaking directly from personal experience with countless accounts that have taken my images, reposted my images without permission, looking for economic gain from my images, I started down that path where I would just send them a direct message and I would ask them politely to remove the image. They don't have my permission. It would go nowhere. So
crossing the bounds of a willful infringement at that point.
Sure. So at that point, my next step was, and this is really nice about Instagram and Facebook and even website providers like GoDaddy or Squarespace or something like that, is they have, by law, they have a process in place where you can fill out a copyright infringement complaint form, and they're required to respond to it within a reasonable amount of time.
Correct.
I would not say that they make it easy for you to do. It's certainly not an easy process to figure out, to get to.
No, it takes some time, and you have to look through it and understand it before you file your first your first complaint that way.
Yep.
Because what will happen, and I think you may have experienced this yourself, is that when you've gone through those steps and you initially send it to them, they may come back to you and say, we disagree.
Do they have a right to do that?
Do they have a right to disagree?
Yeah, if Instagram comes back, and again, folks, this is personal experience. In the most recent last week when I reported an account, I reported them 3 separate times with multiple different images. Not the same image over and over, but I reported them once. Instagram took down the images. Then I was notified again that, by a follower that they had reposted images again. Sure enough, went and reported them again. But this time, Instagram came back and they said, please justify why you feel this is copyright infringement.
Sure. I mean, the answer to that question specifically is yes, they have the right to ask for that justification. Gotcha. If there's a question in the person who's reviewing the initial complaint and they don't have sufficient information to make a determination as to whether the complaint is warranted or it's right, they can ask for additional information, yes.
Okay.
And they probably should, because on the flip side of it, if there could be people who are trying to gain economic advantage by having other people's work taken down, gotcha, when it's actually their work. But I mean, Chris, I know you, and
come on,
I know it's been a long time, and I know your work, and a lot of people know your work, and so, but the people in Instagram don't.
Yep.
And so my point there is that it may take a couple steps to provide sufficient information to the intermediary, whether it's Instagram or other companies, with sufficient justification for them to take that action of depublishing when the person is refusing to do so.
Now, an important note here is, while this, these accounts that have reposted my images, they're clearly looking for economic gain. There's nothing more. They literally, just repost my images word for word, and the only thing that they have in their profile is a link to their online shop where they sell T-shirts.
Right.
There's no authenticity whatsoever. It's not just another person saying,
it's blatant.
"Man, I really love this image" or whatever. No,
yeah.
It is 100% blatant. But having said that, it's our responsibility as well to the best of our abilities, find out what the scope of risk is to us. So if it happened on Instagram, it's likely that it happened on Facebook too. Could also happen on Twitter. And it could also happen on the website where these guys are selling their T-shirts. And it's up to us to figure that out. So just because you fill out, Facebook owns Instagram, and just because you fill out Instagram's copyright complaint form doesn't mean it comes off of Facebook. That's a completely separate process that you have to take.
That's correct.
And that goes for Twitter, and that goes for the website provider as well.
That's right. And it's interesting. There's actually some industry that's come out as a result of this, social media and image posting and copyright infringement. There's companies out there that have the ability of not only registering your copyright for you, but also sending and demanding that the cease and desist letters to the various companies as well as the individuals themselves once they've infringed upon it. They're not too expensive. They may be more than you want to spend if you're a hobbyist or a startup photographer. But if you have a particular work for hire that you've developed and you want to help protect it for the person who you've prepared that work for or created that work for, or if you have some pieces that have been fairly well published, and as a result of that, you've gained some real income from them, and you want to further protect them, it may be in your interest to utilize one of these companies to do that work for you. They can take some of the steps that Chris may do individually, or I may do for him, or other attorneys may do for a less expensive fee than what an attorney might charge.
Why don't we go through? We're about 20 minutes into it right now.
Oh,
Let's
we're having fun.
Yeah, we are having fun.
Only
thought
an
you could
attorney
have
would say
fun.
talking about copyright infringement would be fun.
Then you better watch it because this attorney is a wicked axe thrower. So. Seriously.
One-handed.
Yeah. Yes. Let's go ahead and take some questions and let's see what the audience has to say.
Sure.
So I'm going to go ahead and just take a look through here. Absolutely, Southern Vibes photo. Yeah, it is extremely frustrating. It's almost like somebody pours a hot glass of water over my head every time it happens. It is so aggravating. And more than that, it's very, very time consuming as well. I do this for a living, so taking time out of my day to address matters like this is a waste of my time.
That's right.
Unfortunately.
It really is.
Aaron, hey, thanks for joining. Aaron says, do you have a photo registered before the infringement occurs in order to use that registration in legal pursuit?
Yes. The answer to that question is yes. Check with your own attorney, of course. But what I would suggest is that if you have some works that you've created that you know that you're going to want to market or sell, then go ahead and register them as a collection, because the application process is really quite simple. It's inexpensive, and you can get 150 pictures registered in one application process. And at that point in time, once you have those registered, then you have that prima facie evidence. Again, the copyright protection applies upon the creation, but the perfection of that necessary in order to succeed in court is a registration. Great question.
Aaron, is that good? Happy with that? Hannah, Cowboy Features, thank you for sharing it, and thank you for joining, and thank you for helping promote this all along. It's something that we need to do as a community, regardless of the category of photographer that you are. We all need to collaborate on this together. Sarah, you're very welcome. Good information. Thank you. Let's go back through and see if anybody...
While you're doing that,
yes.
Another topic that often comes up is what happens if I'm approached as a photographer or an artist,
okay,
and somebody wants to use my work. How do you go about doing that? It's actually pretty straightforward. It's as you might suspect. It's preparing an agreement, a simple letter that gives them the scope and the rights of how they can use your work, and you can attach to that license a fee or the other compensation that you agree to. So you can limit that release and that agreement to length of time and the variety of the publications that it may or may not be used in, the nature of the compensation. Get it in writing, have it signed by the parties, have your attorney review it, and then you actually have some additional protections there for not only yourself but also for the person who you're authorizing to use the work.
Sure, that's great. Any other questions from the audience? We have 15 people on. If you have any questions, go ahead and ask them now, and I'll monitor this. In the meantime, though, Scott, with copyright infringement, with the way that we're so social right now, is it fair to say that this stuff is just kind of going to make its way through the courts? Because it seems kind of gray right now, where the courts haven't taken, as far as I know, they haven't taken a real hard stance on, what's published and what's not published. Prior to social media, it was pretty clear. You take somebody like Richard Avedon, and he's published in Life and all these other magazines, but now we have social media, and what's your take on that?
Sure. Well, like any application of law to the evolving society and industries, the way that people get creative, and the courts get creative, and attorneys get creative, and as a result of that, they have to address some of those different creative differences, and so there is evolving case law in this area as far as the copyright infringement in various mediums. There's case law developing as well on the various social media providers as what their rights and responsibilities are, and whether they have liability as a result of allowing infringement to occur. But there's also clear case law out there as to what is published versus what the publication requirements are for infringement or not. as well as what is the burden of proof and the standards of showing that an infringement's occurred. The challenge with the social media world is that it moves very fast.
Yeah.
Very fast.
Yeah.
And so some of the things that Chris was talking about, as far as sending a direct message or sending a letter, and then filing your complaint process, if you have a work that's being infringed upon willfully, and it's something that you anticipate maybe something you want to protect further in court, start building that documentation of what you've done to protect that work from the very beginning, and keep that evidence, because that is a litigator's dream. When a client walks in the door and sets down the paper and says, here's my work, here's what I've done to try to protect it, and here's the inaction that's occurred as a result of it. It makes the case very easy, much easier at that point.
That is a great point. Even when you're filling out those Instagram complaint forms, I keep a record of all of that. I keep a separate folder for past Instagram complaints that I've filed in the unfortunate event that I would have to go way down that road, which, cross fingers. Here's a good question from Southern Vibes Photo. Do you have to have model contracts from the people in the photos to register your images?
So the simple answer there is no, but it depends upon the model and the nature of the work that's taking place. I strongly encourage that anytime you're using an individual within an image, that you get a release, especially if you anticipate making that work available for compensation. And so if you intend on taking that work, publishing it, selling it, making it commercially available, in most instances, the larger organizations that are going to purchase that work from you are going to ask for copies of that release anyway. So take the steps to get a standard form release prepared that identifies the time frame, the individuals involved, and make sure you explain it to them, have them read it, and have them sign it, and keep that along with your documentation of not only the registration of your copyrighted works, but anything else you've done along with that. So yes.
Would that also apply, Scott, in a public situation? So if I'm out, just street photography where there's no reasonable expectation of privacy, would that also apply, or would that kind of be a separate?
Well, every situation is unique.
Yes, it is.
and it depends upon the facts and circumstances. Generally, if people are in the open public and there's a group picture being taken, there is no reasonable expectation of privacy.
Right.
There is no restriction on commercial gain. However, it depends on who's within those groups. There may be instances where there's a celebrity or a person who does have a known image that if it's included within that and it's expanded or it's blown up to capture that, then at that point in time, you could be in effect trying to utilize their image for commercial gain.
That's a fascinating point, because I get notifications of copyright infringement cases, and I just read about,
Really?
yeah, I know, right. I just read about a guy with his iPhone at a wedding who took a picture of Donald Trump. And he posted it to a social media account, and then a bunch of other organizations took that image and started using it, and he ended up suing them for copyright infringement. Now, it was just with his iPhone,
right?
But he won the case.
Sure.
So
that's a great example. Again, the disclaimer: I'm not providing legal advice to any individuals here. Please make sure you consult with your attorney. This is for informational, educational purposes only. Sorry, I have to do that.
Hannah, will you post this video on YouTube? Yes, I absolutely will. I will make sure that this gets up on my YouTube channel. So thank you for that. Where are we at with time, Scott?
It's about 7:35.
7:35. All right, we're down to about 12 people. I feel like we've covered the major topics, and unless there's any more questions out there, we got another one. Let's see here. Sea hanging photography. I do photography as a side job, as a non-professional photographer. Is a watermark the way to mark my photos as my work when sharing on social media?
Great question. That's a great question. So a lot of people believe that once they place a watermark on an image, it's protected. And so really what a watermark is a form of a trademark. That's a brand, it's a logo, it's a type that's used to evidence that it's your work and your, in your case, your part-time business. It is not necessarily, or it is not a copyright registration. You're not required to have that Circle C date, all rights reserved language on the image itself in order for it to have a copyright protection. It does need to be registered with the Copyright Office in order for you to protect your rights should you pursue an infringement action. But it is not in and of itself, that watermark is not the way of evidencing the copyright. However, it does put people on notice that it is in fact your work.
Yeah, the way I like to use my watermark now, much later down the road, is just an identification
Right.
of who made the image, you know, with a personal signature. In the beginning, when I used my watermark, I even used that, you know, Circle C, Chris Dickinson photography. I don't know how many characters that is, but it's a lot of characters,
Right.
and it was all the way across the bottom. And over the years, I've really shrank that down just to the bottom right-hand corner.
Sure.
And that's just a personal choice on my part.
That's right. It's stylistic that way as well. But it is helpful to have that form of copyright notation someplace within the border of the image or elsewhere, because at minimum it puts a chilling effect out there to anybody who may be thinking of infringing upon it. If they see that, they may likely think twice before they take the steps of republishing it.
Dan, thank you, brother. Friend of mine from California,
Hey, Dan.
shoots rodeos. Thanks for all you do educating us aspiring photographers. So.
Well, you know, all you photographers, I'm a frustrated photographer, and I rely upon Chris actually to help educate me and my family on how to take some photographs. But I love this area. Photography is one of my favorite areas of art, and I could spend hours looking at beautiful photography of all types. And so as a result of that, I understand the work, the effort, and the thought that's put behind in developing some of these beautiful works that each of you create. And so that should not go, or should not be taken lightly, and should not be infringed upon and taken advantage of. You've done your work. You deserve to have it protected.
That's a great point, Scott.
Thank you.
Cut Cowboy, what is a way I can get better with my photography, and how should I go about learning more?
Don't listen to me.
Don't listen to him. You know what? I will reach out to you personally, and I'll just direct message you. Southern Vibe, thank you so much for sharing all of this valuable time and information with us. I've been dealing with this daily, and I feel optimistic after listening to this. So.
Oh, wow. I'm sorry to hear you're having to deal with it daily, and I hope that it becomes much easier for you as you go down the road. By the way, www.copyright.gov is the site where you can do your registered copyright submissions. There's also great FAQs on there that can give you additional detail.
Kristen Joy says, thanks for doing this, was just infringed upon today.
Oh.
Makes me nervous to post on social media.
I get that, and that makes a lot of sense because that's a natural reaction. And I would just encourage you to not be chilled in pursuing your art. And if that includes posting your art on social media, please do so. There's some steps you can take to protect yourself, and I would encourage you to pursue those. And as you start doing that, I think it'll help nourish your confidence and allow you to move forward with more confidence.
All right, friends, that's it. I'm going to go ahead and cut the feed. Thank you all for joining us, and I will make sure that this gets up on my YouTube channel. So thank you again, Scott. Thank you so much,
My pleasure.
friend.
You bet.
Always my pleasure.
Have a great evening, everybody. We really appreciate your time, your involvement, and your questions.